Hello.
Yep. Good morning, Gary Apser.
All right. Okay, where are we on this case?
Well, when we last spoke, sir, you said I needed to refund whatever monies the defendant had paid when he first moved in. I sent over a certified letter to both the court and to him. His letter includes the check. It was around $1,500. The letter sent to the court showed a copy of my check. I checked with the UPS or the Postal Service this morning. The court received my letter on the August 1st. It included the copy of the check, the copy of the letter showing that the property was not certified, and a copy of the accounting from my client showing the amount of money I was told to refund. So the court signed for it on the 1st. The Postal Service says that one of those brown notices was left with Mr. Jackson's at his PO box, but as of this morning, he hasn't picked it up yet. But I've tendered to him the 1505 or 1510, whatever it was. I've tendered the entire amount back to him as the court directed. And again, this is a termination of tenancy based on the fact the property is not certified, so there was no request for any supplemental complaint.
I would like to say, like, if it is not like a cause to rent out, why is another person being rented? Another person is here, and another person was already here before I started. And what I like to say is, I feel like I'm really being picked on because just in, I think, June or May, he asked me to pay rent. I tried to pay him before, like last the time we came to court. I tried to pay him. He didn't text back. He didn't call. He didn't anything. So what I told him, I said, all right, I'll just wait till we go to court to show that I tried to pay you. So what I'm thinking is, I think he just got a lawyer and came up with something else smart that would make sense, because he knew that he was wrong, because I tried to pay him and he didn't contact me, didn't call back, anything. I tried to. And I don't get why I'm being targeted and it's someone else living here also. And they was living here before I came here. So I don't get I really don't get it. I really don't get it at all, why I'm the only one being targeted. I tried to pay him. He didn't call back. He didn't text or anything. And he literally just texted me, I think probably May and June, and asked me and contacted me about the rent. So,
okay, Mr. Jackson, stop for a moment.
Yes, sir.
What do you mean that there's somebody moving in?
No, it was someone already here. His name is Joshua. Before I got here, it's somebody that's already here that's moved in. And it's two people that live here. It's roommates. Just for Joshua, and it's me. Joshua was already here when I got here. So I don't get, how is it not rentable and someone else just moved upstairs? Like, these are condos that people buy and they rent out. So I don't get how is that even possible or even logical when someone the owner of a condo here just rented out to two people upstairs. And they told me to contact management.
Stop. Counsel, is that correct?
Your Honor, I understand that there are two people living in this unit, separate leases, and apparently the other person has agreed to move out. He's just there until the place vacates. Nothing to do with Mr. Jackson's tenancy. It was a separate lease, and we're simply asking that he be asked to leave.
All right. Mr. Jackson, how long will it take you to... I got the letter saying that it's not certified, so you can't stay there. There's a check for you that I've got to make sure you get and that it clears. How long will it take you to vacate, sir?
Another thing is, it was first month rent and deposit, and I paid November. So it should be like $1,800. It should be like $1,815.
You paid... No.
First month's rent and deposit was $605, and rent was $605. And
according to the landlord, he paid $300 towards that next month's rent. So that was, I attached the ledger given to me by my client, sir.
All right. So I have $605 paid security deposit, and then $300 payment, and that's October, and then November's rent of 605, which comes to the 1510.
Yeah, but I gave him I gave him for the deposit 605 for their first month deposit and rent.
Well, I have October, you paid a total of 905, which was a payment of 300 and then $600 security deposit. Right?
No, I paid 600 deposit and 600 for the rent, and then I paid November.
Well, I only have 300 paid that first month for rent.
Okay, I really just want this to be over. I'm tired of this landlord.
All right. So when can you? The check is there. When can you vacate?
I don't have a check though. Where do I pick the check up at? Like something came here. So
I think it's a PO box that he sent it to.
I don't have a PO box.
The address on the pleading, sir, was for Mr. Jackson, was the apartment number 1 at the Packard Road address. That's where I sent the check to.
Okay, that's where he sent it. But did you get that check, sir?
No, they left me an orange ticket that said I had to sign for something, and I never got it.
Okay, then you got to go to the post office.
Okay, will it still be there from that day, or will it be shipped back?
Oh, it should be. It was just a few days ago because the court got theirs. My timestamp is the 2nd, so I'm sure it's still at the post office.
Okay. I would like to ask, when is the other Joshua moving out? Like, when is he moving out? Because if this is no one can live here, I think it's fair that we both have to leave.
Counsel, when is the other tenant moving? When is the other tenant moving out?
I wasn't given a date. I was simply told that when Mr. Jackson was out, the other tenant would move out at essentially the same time, but we didn't know when Mr. Jackson was actually going to be out. So I don't have a date, sir. I'm sorry.
All right. Okay. Here's what we're going to do. I'm adjourning this out 2 weeks. You got to figure out your move out date, Mr. Jackson. Maybe you can ask the guy upstairs or whatever. And you need to pick up the check, get it to the bank or wherever you do that so that it can get cash. Okay?
All right.
So the 18th. So this will be adjourned to August 18th, 2023, 9 a.m. Thank you.
Your Honor, what's the purpose? Is the purpose of the adjournment to make sure the check clears? I guess I didn't follow the reason for the adjournment.
Well, the reason for the adjournment is to try to get a move out time because the whole building won't be empty, and also to make sure he gets the check and that it clears.
Okay. I just want to make sure, because if it's a matter of the check, that's fine, but I don't have a timeline for the other tenant, but I can get one.
Thank you.
CR 387. Brett Sweeney appears for the state of Kansas. James Watts is defense counsel. Defendant Fry appearing from the Sallyport Zoom location. This matter comes before the court at this time for hearing on a warrant to show cause alleging probation violation. Those violations include the defendant failing to notify her ISO within 48 hours of law enforcement contact, failing to obey the law due to some traffic matters, positive sample for fentanyl and alcohol, allegations 4, 5, 6, and 7 all deal with submitting positive fentanyl tests. Number 8, failing to make monthly payments. Number 9, unsuccessful discharge from a higher ground outpatient. All as alleged by Christy Ashenfelter, Community Corrections ISO, who is present on this meeting with us. What is the defendant's position regarding these allegations, Mr. Watts?
Your Honor, discussed the matter with my client. It's my understanding she would stipulate on each of the allegations that she failed to notify within 48 hours, that she failed to obey the law, that she submitted a number of positive samples for fentanyl and or alcohol with Higher Ground. It's clear that she has not failed to make monthly payments and she was unsuccessfully discharged. So she would stipulate to those violations and waive hearing on the matter. She would ask the court to know that she is currently in treatment at outpatient treatment or at Recovery Concepts and has a bed date at Mirrors in Newton coming up in, I believe, September 15, if I wrote my date down correctly.
And what is that date for, Mr. Watts?
That's for an inpatient treatment bed, Your Honor.
All right.
But she
Mr.
would.
Fry, your attorney has made an announcement on your behalf that you now intend to waive any formal due process hearing you'd otherwise be entitled to, where the state would have the obligation of proving these allegations by a preponderance of the evidence. You have the right to challenge the state's evidence. You can present evidence on your own behalf, confront the state's witnesses unless good cause was shown. And I need to point out to you that among other lesser remedies, the court could consider an outright revocation of your probation and ordering you to serve the remaining balance of your sentence locked up. Do you understand these things, Ms. Fry?
Yes, Your Honor.
And do you waive a hearing in this case?
Yes, Your Honor, I do.
And agree and stipulate that you committed these violations as outlined by Mr. Watts and earlier read by the court?
Yes, Your Honor, I do.
Very well. The court finds that Ms. Fry has made a knowing waiver of her right to a hearing and stipulates and agrees that she's committed the violations as stated by Mr. Watts here on the record. The court finds that these are substantial and material violations of the terms and conditions of her community corrections assignment and her probation. The court will now turn to disposition of this matter. The court will ask for recommendations from various persons involved in this meeting, starting with Brett Sweeney on behalf of the state of Kansas. Mr. Sweeney?
Yes, thank you, Your Honor. First and foremost, I showed this case that she's was placed on probation back in November of 21. She had a dip with Miss Ashenfelter in September of 22. When she was initially sentenced, it was a border box case. It looks like, and in speaking with Miss Ashenfelter, that Miss Ashenfelter has secured an inpatient treatment bed with Mirrors on September 15th. This is not a Senate Bill 123 case, so Ms. Ashenfelter, it sounds like, had to work to secure some funding to help subsidize that treatment, but she has. So the state is recommending that she be held in custody until September 15th in the hopes that there's kind of a seamless transition from a jail setting to that inpatient treatment setting at Mirrors. And specifically, I know Ms. Ashenfelter was worried about the fentanyl usage, which I guess she didn't learn about until some time after there had been, it sounded like, some of the issues in the last, with some of the previous UAs with Higher Ground. So we think that that's needed. That would be approximately about a 41 day jail sanction, and then placed into inpatient treatment and then back on community corrections probation with all the same and previously ordered conditions. And then we ask the court to look into costs and fees additional as well.
Very well, Mr. Sweeney. Mr. Watts, your recommendation to this court?
Your Honor, I understand the state's recommendations, and there's a part of me that thinks that that makes some sense. My client notes that since her last UA in March, she has submitted, or she tells me that she has submitted a number of samples since that time and have come up clean on those samples. So she is making progress in that use. She noted she just started a new job, but was concerned about, should the court order a sanction, how she might do that and keep her job. I know that ordering her into custody until her inpatient time in Mirrors would probably effectively end that new job. Judge, she should be ordered to enter that treatment facility in Mirrors, and there probably should be a sanction in the meantime. My concern is that the progress that it seems like she has seen in that time, and that she's now providing clean UAs and has a job waiting on her, may well be lost by remanding her to custody until that mid-September date. Judge, I'd recommend a sanction period that the court believes is appropriate in the 5 to 10, maybe 15-day range, and an order to place her back on probation with an understanding or an order that she enter that treatment program at Mears and Newton.
I understand your recommendation, Mr. Watts. What are your fees in this round of representation of this client?
Judge, this would build the bids at $800.
Thank you. Ms. Ashenfelter, as the ISO from Community Corrections, in essentially supervising this case, do you have any additional recommendations or remarks?
No, Your Honor.
All right, thank you. This time the court will address the defendant, Ms. Fry, personally, and I'll ask her if she has any statements that she wishes to make in mitigation of punishment or anything further that she would like to present to the court. Ms. Fry?
Yeah, Your Honor, I'd just like to say that, there is no excuse for my actions. However, the last 4 or 5 months, I have not been using. I've been passing my UAs. I'm back in treatment. I'm want to go to inpatient treatment, so that's no doubt about that. I did just submit a UA too this week on Monday. That was clean. I had surgery on my hand and I was off from work for a few weeks. I'm now back working. And I'm back in guidelines with everything I'm supposed to be doing. And I would just ask that maybe adopt the recommendations for a shorter sanction. And that's all, Your Honor.
What kind of work are you currently doing, Ms. Fry?
I'm CSR customer service representative, and then I also take care, do home health care.
All right. Thank you. Court is prepared to rule on disposition. Previously, it had made a finding that there were substantial material violations of the terms and conditions of probation in this case. The court overlooking law enforcement contact issues and essentially the traffic matters, which the court certainly can't bless this defendant doing, nevertheless, doesn't provide this court any real direction about how Janie Fry is doing. The court's greatest concern, Ms. Fry, is multiple sample positives for fentanyl. You are a border box case, which means that the court had the discretion at time of your original sentencing just to put you in prison and not even give you an opportunity for a community-based alternative. But the court resolved doubts in your favor. I wanted to see you make it in the community. I didn't want to see you in prison, with the idea that you would seek rehabilitation and treatment in the community, be successful at that, become gainfully employed, and stay clean, or at least close to being clean at a minimum. The fact that you're being consistently involved with one of the most dangerous street drugs that anyone could concoct boggles my mind. You know better. People are dying from this drug. Surely you know that, and yet nevertheless you're having multiple contacts with it. Now you claim today on the edge of prison that you've come clean. I don't know what along the line here you didn't understand about being clean before now. Is it because you really think that you're truly facing prison now, that you're finally starting to turn it around? I don't know. The court considers you to be a great risk to return to the community. Quite frankly, I would rather see you in prison than see you dead from a fentanyl drug overdose. And you don't seem to be able to make consistently good decisions about staying away from it. In looking at the allegations on your warrant to show cause, it almost suggests to this court, Ms. Fry, that you're just a total failure on this community corrections program. The only thing that changes that in the view of the court is that you have had some recent indications that maybe things are improving. And this court really does hate to interfere with that. I like the fact that you apparently are having some clean UAs now and that you're working, but you have such a track record of failure on this long-term probation that this court granted you, that the court's not going to ignore that, Ms. Fry. However, I'm not willing to declare this a total defeat either. And I believe Mr. Sweeney's recommendation to the court is sound, and the court will adopt it. This court is going to order Ms. Fry as a sanction for noncompliance with the terms and conditions of community corrections probation into custody at the Butler County Jail from now until September the 15th. I'll order her released on September 15th for purposes of being transported to what appears to be an arranged inpatient bed at Mirror. Perhaps in a confined setting like that, treatment will finally take. In other words, the ability to make better decisions when you're under stress, Ms. Fry, because you're making a lot of bad decisions.
Your Honor, may I say something?
You may.
The whole time I've been on this case, I was doing really good. I was passing all my UAs. The beginning of the year, there was an incident with my children in a sex case, and they got taken out of that home, and that's what triggered my use. As soon as I seen that it was getting out of control, I got myself back into drug and alcohol. Christy didn't recommend it. I did it for myself. And then once I started taking that program and doing that program, I've been clean. I've been passing all my UAs, several in the last 5 months.
If you think that's going to change the court's mind, Ms. Fry.
I just wanted to let you know that, because I don't feel that I've completely failed the program, because the last year or so I was doing really, really good. I was
Ms. Fry, if I thought you had completely failed the program, you'd be sent to prison today.
Okay, yes, sir.
All right. You have one more chance. However, I agree with Mr. Sweeney. I don't want to take the risk that you're going to relapse on fentanyl between now and the time that your inpatient bed becomes available. Let me also point something out to you, Ms. Fry. Stresses in your life are not over. They're going to keep coming. And the real issue is, how are you going to deal with those when they arise? And treatment, a proper treatment program, can assist people in dealing with stress and how to handle it without going to drugs like fentanyl or alcohol or marijuana or cocaine or anything else. So the court believes that the step that's being recommended by the prosecution is the appropriate one. I'm going to impose that sanction time until your inpatient bed becomes available. And that date apparently is September 15th for a sanction for noncompliance. And that's not even as long of a period that this court could impose as a non-prison sanction. But I find that to be adequate. I think that's 42 days, Mr. Sweeney, if I'm doing the math correctly. So the court will impose a 42-day jail sanction essentially till September 15th for her to be released to go to her inpatient program at Mirror. And then she'll be reinstated on community corrections. Any unsatisfied condition remains. No additional assessments will be made in light of the fact that I'm essentially depriving her of her ability to work for this sanction period. Certainly she's earned that, but nevertheless, I think looking at finances realistically, I think it would be inappropriate to assess anything more for legal fees or expenses at this juncture. Anything previously imposed remains to be paid. Ms. Fry, I really hope that you don't relapse again once you get out of treatment. I really hope you can be successful from here, and that I don't have to review this sentence again, and that you can work with Ms. Ashenfelter or whoever's going to be supervising you at that point and truly successfully complete this program. This court is going to extend probation in this case, Ms. Ashenfelter, for an additional 6 months until April 18 of 2024. Ms. Ashenfelter, as always, if your department believes that she has successfully completed the program, or would entertain an order of early discharge. But for now, I think I want to make sure you have adequate time remaining to work with her on treatment and follow up to treatment to see that she's truly successful before releasing her off supervision. So she's now extended to April 18, 2024. All right, Mr. Sweeney, is there any other matter that the court needs to address regarding Ms. Fry at this time?
No, Your Honor.
Mr. Watts, anything further?
No, Your Honor, thank you.
Ms. Ashenfelter, do you need any clarification regarding the court's orders?
No, Your Honor.
I trust that the protocol you would expect is that when she's released and I don't know exactly how she gets transported to treatment, but she'll be in immediate contact with you when she's let out of jail. Is that what your expectation is?
Yes, Your Honor.
Okay, Ms. Fry, you have her number. You'll need to make sure you call Ms. Ashenfelter just as soon as you're released and are able to do so.
Okay.
Well,
I'm supposed to be there at 11 a.m. Are they going to release me before that so I can get there?
that's what the court contemplates.
Okay.
I don't know if that's some direction that can be given to the jail, Adam, but I do want her released in time to make her appointment on treatment that day. If can be arranged by the jail, 9:30, 10 o'clock, whatever it takes, so that she can get there for her appointment. I want her to set her up for success on that. I don't want her to start off getting there late. So that's certainly what the court's contemplating at this time.
If it's okay with you, on the jail admissions sheet, I will put on there that she's to be released at 8:30. That gives her an hour and a half to get to Mears.
Well, that would give her, I think her appointment's at 11, isn't it?
Oh, 11?
Yeah, but I also need clothes, get my clothes and stuff because I'll be there for 30 days. I won't have
Okay, but if you're out for 2.5 hours, you're not going to mess up, right, Janie?
no, Your Honor. No.
All right, Adam, 8:30 a.m. is fine.
All right.
Thank you. All right, good luck, Ms. Fry. I believed in you when I granted border box probation. I still believe in you now. Take advantage of this last opportunity, okay?
Mhm.
All right. I'll remand her custody to the Butler County Sheriff's representatives till she can be remanded to the Butler County Jail to serve until September 15th at 8:30 a.m.
That's it. We back, huh?
Sir, can you stop talking? Sir, can you please adjust your camera so that we can see you clearly? Sir, can you turn your camera around so you're not sideways? All right, I'm ready on Anderson. This is case number 205655401, the people of the state of Michigan versus Corey Wendell Anderson. The defendant is charged with 1 count of disorderly conduct. Today is the date set for an arraignment on a bench warrant. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Good morning, Your Honor. Ivan Land, P65879, appearing on behalf of Corey Anderson, who's present on the screen. Your Honor, we have no objection to holding these proceedings by Zoom. Thank you.
You're welcome. Did you say your P number? I'm sorry.
Yes, P65879, Your Honor.
Mr. Anderson, please unmute and state your name.
Anderson.
Please state your name and turn off your devices. State your name again, please.
Corey Wendell Anderson.
Today is the date set for an arraignment on a bench warrant. Mr. Land, as to the arraignment on the bench warrant,
We stand mute, Your Honor.
court enters a not guilty plea. It appears that Mr. Anderson actually capious from a review that he is on probation to the court. Whoops. That his probation officer is Lori Bumpus. that he was placed on probation by me October the 21st, 2020. He is going to have to turn off his other devices.
Okay.
He was ordered,
Yeah.
sir, what is going on? Let me come up. I'm gonna need you to be quiet. I'm gonna need you to make sure all your devices are turned off. Okay. I don't even know what this means, conservation restitution. I have no idea what that means. They must have, somebody typed that in wrong, because I don't even know what that means. But his total fines, costs, and fees look like it was $1,020. It was delayed under 771. It's no longer delayed under 771. He was given 3 days credit for time served in jail. I said I would consider an early review after 5 months. And then that was in October 2020. And then he was supposed to come for review in March of 2021. He failed to appear. A bench warrant was issued. And then some kind of way he made a payment, even though it should have been, he had an arraignment on the bench warrant in 21. And then I said he must have started his probation and paid some money by July 14th. When July 14th came, he didn't come. So then he's been in warrant status since July 14th.
So are there new charges of disorderly conduct, or this is just a probation violation?
No, this is just a probation violation.
In the original charge was it the curfew for the COVID?
It was something.
Yeah, Your Honor, so I can explain about my client. So my client, in his defense, he lost 7 family members to COVID, and it was after a funeral. Police came past the curfew. I know a lot of judges didn't like that particular law, but it was a law, Your Honor. My client is I
wasn't one of those judges.
Yeah, I know, Your Honor. Outstanding guy, Your Honor, helps people around the community.
Well, why did he go missing?
Your Honor, he's under my watch now. I can't answer that. I know his family. I've been knowing his family my whole life, Your Honor. Let several tenants that could not afford their rent. He didn't try to get the Sears money or anything. He didn't try to evict them. Outstanding gentleman. And I heard this court state that they would remove his 771.1, Your Honor. I would ask that the court not do this. My client can make the full payment of anything he owes today, and he would ask that this matter be closed out, Your Honor. He's not a bad individual, Your Honor. But I did explain to my client, I know COVID was tough on everyone, lost a family member, had a disagreement with some police officers, Your Honor, and he's before this court, which I told him, I know this court is very fair, but if he must obey the laws of this court, Your Honor, and he does apologize. And, as far as his cell phone, Your Honor, he understands that he needs to turn it off, but he has a lot of, I would say, elderly clients. So he actually sleeps with his ringer on and forgot to turn it off, because he really does help the community, Your Honor. I know it doesn't sound like that the way he fails to appear in court, but Your Honor, I would ask for you to give him the benefit of the doubt and allow him to keep 771.1 and just close this matter out, Your Honor.
I have to tell Ms. Stevenson sometimes, I said, "Ooh, if I could have my eyes closed, and just hear what the lawyer says about their client, that would probably go a long way. But it's not the fact that he had the phone on, it's the fact of how he responded when I said he had to turn the phone off. Right. And right there, like it just don't be necessary, right? It's not necessary. So what I did was recite everything that was taking place in the register. That's all I did, was recite it.
Yeah.
And then because the law says that if a person, the sentence can only be delayed for 12 months. So that's where we mess up, when we don't come back to court in the 12 months. That's not my fault, that's his fault. The law said 12 months. You gotta delay the sentence within 12 months. And if it ain't in 12 months, then it's no longer delayed. Now, it appears that he already paid the money.
Okay.
Right? It looked like he has a zero balance.
Okay.
Looks like he already paid the money. Looks like the great man that you speak of just needed to come to court. That's what it sounds like. Now, he paid the money after the 12 months. He paid the money after the 12 months. Let's see. Looks like he paid the balance. Let me go back up. When did I put him on probation? Maybe not. Let's see. Oh, and he was supposed to do 5 days of community service. So he's supposed to do 5 days of community service and pay the money. He paid the money and he didn't do the 5 days of community service. But let me see when he paid the money. Then that's when he came back to me in 21 and I said he needs to have that money paid, some money paid. Then he did pay.
May I interject when you allow me, Your Honor?
Mr. Flanagan, what does conservation restitution mean?
I'm looking at that too, Your Honor. That must have been an old entry code or something, because I've never seen that before.
Okay. So then I'm looking at May 4th and it says credit card tender. That means he paid $720, right?
Yes.
Okay, and that was before the thing. And then his balance today is zero, right?
Yes.
Okay. Yes, Mr. Land.
Your Honor, and I'm not trying to be snotty, but you are the boss, Your Honor. I really don't care what the law says. You can do it, Your Honor.
I would never do that, Mr. Land. I would never do that.
You are the boss, Your Honor. I know they have laws, but
I'm the boss. However, I'm the boss and I'm in the judicial branch, and the legislators are the legislators and they make the law. Whether I agree with them or not, it is my, unless I believe them to be constitutionally in error, it is my obligation to follow them. Now, that being said, it appears that Mr. Anderson did actually pay the money within the 12 months. He had a zero balance. I don't know what happened to the community service, but I just have a good feeling that he didn't do it. But let me just say this, and then I'm gonna tell you my decision.
okay.
Yeah, I wasn't one of those judges who didn't like the curfew, because y'all should have had your hand parts at home. It was stay home and stay safe. And then we talking about everybody dying from COVID, and I am so sorry for his loss. I'm sorry for the loss that I suffered. I'm sorry for the loss that you suffered. But if we were staying at home and staying safe, some of us wouldn't have been suffering the loss. And so I am one of the people who took that order very seriously and was irritated at the people that was out in the park and stuff, partying and all of that. So having, trying to make sure that my elderly loved ones were safe and not infected, and all of that. I stayed my hind parts home, and I stayed safe. And I lost some people, not in my family, but people who were very near and dear to my heart, because people wasn't staying home and staying safe. But having said that, I am willing to waive the community service because I have a feeling he didn't do it, and I'm not going to even check and see, right? Because I have a good feeling he didn't do it because he was gone. He'd been gone all that time. He did pay the money. And additionally, I already had given him credit for 3 days. So when I sentenced him, I must have been really feeling real strong about the fact that y'all wasn't staying home and was arguing with the police when they was trying to get you to go home. It don't matter if somebody is deceased. Don't matter if we were out at the funeral. It doesn't matter that we were grieving at the time. If the people told you to go home because it was a curfew, go home. Go grieve on your front porch. Go grieve in your backyard, but get off the city streets. So I don't know. I must have been feeling real strong because I gave him community service and credit for the 3 days. So I'm going to take away the community service. He has the credit for the 3 days served in jail, and he paid the money. I am going to therefore honor the delayed sentence because it was completed within the 12 years, not because I'm the boss and the most important judge in the whole world, but because he completed it during the time that the legislators have set for him to complete it within. So we are going to close Mr. Anderson out of this probation. I will honor the delayed sentence. I will dismiss the matter with prejudice, and I will set aside the conviction. Mr. Land, if you could send that dismissal to the clerk, dismissal with prejudice to the clerk, and then I will have probation submit the order of discharge. Anything further?
Always a pleasure, Your Honor. Thank you so very much.
Always a pleasure. And
Take care, Your Honor. Stay safe.
It's good to see you still doing this.
Yeah, the big
All
day.
right.
The big day is in 2 days, so
Really?
Yeah. So
I understand. I
Yeah.
definitely understand. All right. Well, you take care and be strong. Okay.
I see you got your APA looking like a movie star.
That's her. But oh wait, what happened to he must have made a mistake and pushed delete as soon as he said that. I was gonna tell him, no, that was you. That's your Beyonce look. All right, Mr. Anderson, we'll mail you a copy. Because I didn't remove Mr. Land. I didn't remove him. All right, Miss Stevenson, I got